So the first steps to take after being arrested in California is 1, assert your right and do not speak about the facts of what exactly occurred. 2, ask for an attorney and do not answer any questions unless your attorney is present. And 3, call our office for a consultation as soon as possible, because the sooner we get involved, the better your defense will be. So during an interrogation, the way to protect your rights is you obviously want to assert the fact that you want your attorney present. Why? Because the attorney can go ahead and advise you as to which questions you should and should not answer, and when to exercise your right to remain silent. Also, make sure that once you assert your right to remain silent and have your attorney present, don't open that door, because cops sometimes will keep asking. If you open the door by answering, you can no longer assert your right, and they take it as you've waived your right. So make sure that once you've asserted your right, that you remain quiet and do not answer any further questions. So the options for a person who has been arrested are multifaceted. It could be the traditional bail. So there's a bail schedule for both misdemeanors and felonies, and the arresting agency can go ahead and set bail as per the bail schedule. You can also go before the court and ask for pretrial release. Nowadays, the courts are taking into account a person's ability to pay to make sure that justice is equally imparted, not only between the people who are more affluent and have the ability to bail out, but also for those that do not have those readily monetary abilities, so that they can go ahead and be released and assist with their defense. So what to expect at the first court appearance? First court appearance is what we call an arraignment. An arraignment is merely the formal presentation before the court of what the charges are against you. At this point, we usually do not allow our client to make any declarations. We speak for them with regards to a declaration of not guilty to start the proceeding of compiling all of the evidence and seeing what is the best option for our client. So after your arraignment, what happens is there's a series of pretrials. If they're misdemeanors, we'll call them pretrials. If they're felonies, we may call them felony settlement conferences, early disposition conferences, or pre-preliminary hearing status. In all of those, our focus at that point is to compile all of the evidence that the district attorney has against you, whether it be the initial police reports, whether it be audios, videos, and if, for example, on a DUI, if there's machinery that is involved, we look at maintenance and calibration logs of those machines. So I would say 2 to 3 of those hearings subsequent to the arraignment will be for the compilation of all of the evidence. And once we have all of the evidence, then we enter into negotiations. So if you find yourself going through a criminal arrest, an investigation of any sort, I invite you to call Confianza Legal as soon as possible so that we can assert your rights and make sure that your constitutional rights are protected. So go ahead and give us a call, Confianza Legal.